introduce our speakers today. Let me spotlight them so that you can see them. But let me introduce Keygan. Keygan Miller is an advocacy manager for the Trevor Project, the nation's largest suicide prevention and crisis intervention organization for LGBTQ young people. Keygan is responsible for the research, advocacy, and legislative agenda for the Trevor Project in the area of school suicide prevention policy. Keygan previously served as a special education teacher for Cincinnati Public Schools, where they taught math and science, led as a school-wide testing coordinator, and advised the student council. Thank you for being here, Keygan. I'm so excited that you're here. And Keygan's been to a number of these summits before, so it's great to be back together. I'm also very happy to introduce Anne Cook-Graver, who is a supervisory civil rights attorney with the U.S. Department of Education Office for Civil Rights, Chicago Enforcement Office. Anne oversees a team of attorneys and investigators who work on complaints of discrimination based on sex, disability, age, national origin, color, and race. Anne specializes in sex discrimination in athletics, discrimination based on LGBTQ identities, and issues affecting people with disabilities. Anne served as the Disability Rights Bureau Chief at the Office of the Illinois Attorney General before taking her position with the Office of Civil Rights, the Office for Civil Rights, sorry. Welcome, Anne. Thank you so much for joining us today. It's so wonderful to have you. I'm just going to read Asaf's bio. So Asaf, who is having technical issues right now, is my colleague and senior staff attorney at the National Center for Lesbian Rights. He's also director of our Transgender Youth Project. He works to safeguard the rights of transgender and gender expansive youth to be affirmed and supported for who they are. By changing the life trajectories of transgender and gender expansive youth through litigation, public policy, and advocacy, Asaf hopes to create a future where all children can thrive. So hopefully he comes back, but with that, I'm going to turn it over to Keygan and Anne for now.
Thank you, Ming. Thanks so much. So we go until 5:30. Is that correct? Is that a strict cessation or end, Ming?
A little over. The next session is at 6. So we
okay.
Half an hour.
Okay.
Yeah.
We'll keep that in mind. So my presentation, I don't have a PowerPoint. I just wanted to talk to you about basically two things. I'm going to give you an overview of the history of the Department of Education's policy and regulations affecting students who are LGBTQ+. And then I'm going to talk about OCR complaint process. So as far back as 1997, OCR has found that has interpreted Title IX to prohibit harassment and discrimination against students based on LGBTQ status. This was as early as 1997 when OCR issued its first sexual harassment guidance. We amended that guidance in 2001 and again stressed that Title IX covers LGBTQ students. And there's Asaf, welcome. And the next proclamation that OCR made indicating that Title IX covers LGBTQ+ students was in 2010 when we issued a bullying Dear Colleague letter. Now, during my presentation, you'll hear me say Dear Colleague letter a lot. And what that is an official letter written by our Assistant Secretary, sometimes along with the Department of Justice, that is issued to heads of educational institutions that receive federal financial assistance. So we refer to those as stakeholders or recipients, and they are the people who receive actually a letter, either electronically or hard copy, that says, here, hey, this is how OCR interprets the law. So back in 2010, the stakeholders received that letter. And then working up to 2016, OCR issued a Dear Colleague letter on transgender students. particularly addressing the rights of transgender students. And significantly, it said that Title IX obligation to ensure non-discrimination on the basis of sex requires schools to provide LGBTQ plus students equal access to educational programs and activities, even in circumstances in which other students, parents, or community members raise objections or concerns. And I think I've heard that before in presentations that, oh, you know, they canceled our GSA group because of the objection of parents or students. It made them feel uncomfortable. As early, well, not that long ago, but 7 years ago, OCR said that is not a defense. Stakeholders and recipients cannot use that as a defense to cancel out or refuse to fund such groups in schools. I think you'll have questions for me about that later, but unfortunately, following through, Title IX protection of transgender students temporarily stopped in 2016. This was because in 2016, August of 2016, a federal district court in Texas held that the term sex as it appears in Title IX unambiguously refers to biological sex. The court ruling stopped, or in legal terms, enjoined the Department of Justice and the Department of Education from defining a student's sex as the student's gender identity under Title IX. So when that happened, we had to close any complaints filed on the basis of discrimination of transgender students. However, a couple months later in February 27, no, excuse me, that was in effect for about 4 years. And then we had the new administration come. Shortly after President Biden's inauguration, he issued an executive order called Preventing and Combating Discrimination on the Basis of Gender Identity or Sexual Orientation. So this explicitly contravened or contradicted that 2016 federal district court injunction. And it said, sorry, folks, every person should be treated with respect and dignity and not live in fear. It basically directed all heads of federal agencies to get to work on amending your regulations, your policy guidance, your policy documents to cover non-discrimination based on transgender status or sexual orientation. So again, this is not the force of law, but it's definitely a presidential edict to departments to whip into order and start protecting students based on gender identity or sexual orientation. 1 month later, the president again issued another executive order called Guaranteeing an Educational Environment Free from Discrimination on the Basis of Sex, including sexual orientation or gender identity. As you know, the previous administration, I don't think even uttered these words. So to have these appear in a executive order, it was pretty significant, at least for the employees of the federal government. Again, it reiterated all students should have an educational environment free of sex discrimination on the basis of sexual orientation or gender identity. And it said this is codified in Title IX. So there's been a few years of disagreement as to how Title IX defines sex. And we'll get into that a little bit more. But right now, under the current administration, OCR and other federal agencies define sex as gender identity. So this executive order said that the Department of Ed shall consider taking additional enforcement action to account for sex discrimination against students who identify as lesbian, gay, bisexual, transgender, or queer. So it specifically, it singled out the Department of Ed and said, you guys better get on the stick and do something. So in April 6, 2021, our assistant secretary wrote a letter to stakeholders, and it just basically indicated to the stakeholders, yes, we're going to take action. It said OCR is reviewing regulations, policy guidance, and agency actions, and it will conduct public hearings on Title IX. And one of those issues during the public hearings can be transgender or the coverage of transgenders or sexual orientation. Those public hearings were held already, and quite interesting to read the transcripts, voluminous amount of transcript pages. And basically the secretary indicated that we'll be working on this and will ensure that claims of sex discrimination and sex harassment will be handled promptly and equitably. So a couple months later, our office published in the Federal Register, which again is not the full force and effect of law, but it's pretty strong in its opinion that courts often follow. And what we published in the Federal Register was a notice of interpretation. And basically, it said a lot of things, but it said, look, we believe that the Supreme Court case called Bostock v. Clayton County, and I know you guys have heard of that before, but as a reminder, Bostock v. Clayton County was decided in 2020, and it involved gay and transgender employees who had been fired because of their sexual orientation or gender identity. The court in Bostock held that the negative treatment of employees because of their sexual orientation or gender identity is discrimination based on sex and is unlawful under Title VII, which is the law that applies to employers that prohibits sex discrimination. So this notice of interpretation said, look, Bostock said that Title VII applies to employees. We're going to carry over that definition, and we interpret Bostock to say, yep, Title IX also covers students based on gender identity or sexual orientation. Several cases have followed that and endorsed the definition of sex under Bostock. I have about 1, 2, 3, 4, 5, 6, 7 examples of that. And I should have told you before I started speaking, Ming emailed to you with the invitation this morning, a document that has a lot of links. It has links to everything that I'm talking about today, such as those executive orders and even these cases that cite to Bostock and say, yeah, Title IX applies to transgender students. So if you need to see that or are just interested in reading some good case law, just look at that attachment that on the email that Ming sent you today. And I see some people laughing when I said good case law, but a lot of times they're really well written. And, you know, I learn from reading them sometimes. What I mean is regarding my writing. Anyway, following through, in just last summer, in June 2021, our office issued a fact sheet on combating anti-LGBTQ plus harassment. And again, if you'd like to see that, you can get that in the document. It's linked in the document. And basically, it provides examples of harassment of LGBTQ plus students. And that's mostly for the edification of administrative staff, of teachers who may be working with such students. You know, it's kind of a slap in their face saying, hey, wake up. This type of harassment is harassment of LGBTQ students. For example, transphobic or homophobic slurs, physical violence, of course, and using a student's former name or referring to that student with incorrect pronouns. So that is actually stated in this fact sheet and could really serve, I think, a lot of administrators and school staff in North Dakota and everywhere, not just North Dakota. Finally, I just wanted to share with you what happened to the Department of Education, Department of Justice, and the EEOC over the summer. In August 2021, 19 states, led by the state of Tennessee, sued our 3 departments in federal district court in Tennessee. And the lawsuit asked the court to make these 3 agencies, ED, EEOC, and the DOJ, to stop applying Title IX to claims of transgender discrimination for 2 basic reasons. It points to Title IX already, and it says, look, Title IX permits sex separation on the basis of biological sex. Look at how we look at sex discrimination in educational institutions, or Title IX allows the separation of sex in athletics. So of course, that's how Title IX sees sex as biological sex. OCR doesn't necessarily agree with that, but that's what the lawsuit is claiming. Secondly, the lawsuit claims that Bostock v. Clayton County, the case that I was just speaking about, expressly disclaimed any intent to interpret other federal or state laws that prohibit sex discrimination. So right now we're battling that lawsuit. Nothing has been determined, so we continue to enforce Title IX to protect students' rights based on gender identity or sexual orientation. And I know, let's see, I think I'm about on 25 minutes, but I just wanted to share with you a video, and if Ming is around, I'm trying to wake him up. I have a video of a short interview of our Secretary of Education. And if he can share that with us now, I'll go on mute and see what we can do.
Great, yes, here we go. Can everybody see the video? Okay.
Looks good, Ming.
U.S. Secretary of Education Miguel Cardona grew up in Connecticut, minutes from ESPN's headquarters. He visited recently for one of his first interviews as a member of the president's cabinet.
What is your view on how transgender athletes should be treated and when and how they should compete?
Transgender athletes are students, first and foremost, and they deserve every right that every other student gets. That means a good education. That means access to extracurricular activities, be it theater, sports, it doesn't matter.
So what do you say to the argument that allowing transgender athletes to compete in certain competitions is unfair to female athletes?
I recognize there's a lot of concern around that issue, but what's not tolerable is saying that some students cannot participate because of their gender. LGBTQ students have endured more harassment than most other groups. So it's critically important that we stand with them and give them opportunities to engage in what every other child can engage in without harassment. I do believe in local control, I do believe in state control, but we do have a responsibility to protect the civil rights of students. And if we feel the civil rights are being violated, we will act.
During the last administration, the rules regarding how schools had to respond to complaints of sexual assault, sexual violence, sexual...
Thanks.
What is your position?
Thanks a lot. Yeah, that was quite moving when I saw that. I don't think a Secretary of Education has ever spoken up like that before. So hopefully our enforcement will follow. Before I go on to talk specifically about how OCR does and how it does what it does and how you can interact with us, I want to see if there's any questions. Afterwards too. Thanks, Ming. We'll have time for questions afterwards. So, and I know that was just like a spew of policy and guidance. So I just wanted to share with you OCR's experience up till now. Actually, my numbers that follow are from January 20th, when the president was inaugurated, to today. So right now, OCR Chicago and our office covers the states of Illinois, Indiana, Iowa, Minnesota, North Dakota, and Wisconsin. So of those 6 states, we have 43 complaints alleging discrimination based on gender identity or sexual orientation. And it'll be interesting for you to know that only one of those complaints come out of North Dakota. As far as I know, there's another woman on this call who works in my office who covers North Dakota. Her specialty is North Dakota. And if she knows otherwise, but I did a search and it's only one complaint filed in North Dakota. Nationwide, as of today, OCR has 290 complaints alleging discrimination or harassment based on LGBTQ status. So I wanted to give you an example of what type of claims we're seeing. For example, we have complaints where school staff fail to respond to verbal harassment of LGBTQ+ students. A claim that gay pride displays and rainbow flags were removed or ripped down after students expressed discomfort. Some students just ripping them down who are opposed, or the actual administration taking them down. Transgender students prohibited from using facilities, restrooms, locker rooms with which they identify. A principal refusing to remove anti-gay poster from the hallway. A gay straight alliance prohibited from posting flyers or raising money, while other clubs are permitted to do so. School staff and students refuse to address transgender students by preferred name and pronoun, and social media harassment. So our office, we take complaints from anybody who witnesses discrimination. The issue being that if you witness discrimination against a child, you will have to obtain consent from that child's parent or guardian, and that's merely having them sign a form and sending it in to us. For students who witness or experience discrimination, you certainly can file a complaint with us, but a parent or guardian would have to provide consent for us to proceed to investigation. And maybe I'm getting ahead of myself, but the way you can file a complaint is in that document. You can file a complaint by clicking clicking a spot on our website. And I do have a link to that in the document that Ming sent you earlier today. So there's also some threshold questions that we will ask before we would investigate any claim. First of all, the discrimination or harassment has to have occurred within the 6 months prior to you filing the complaint. So if the discrimination occurred more than 180 days before the date you filed, we can't look into it. There's a few exceptions, but one exception is if that discrimination keeps continuing. We call that a continuing violation, and we may be able to look into that. Often harassment continues, and it may have initiated 2 years ago, but is continuing. So that could be something where we would look at timely harassment and then look at harassment that began 2 years ago. And you may hear this again, but so many times we get claims, especially now with so much social media, TikTok and Facebook and Instagram, and I'm going to date myself because I don't know all the names, but a lot of harassment occurs after school, in one of those domains. And the only way we could look at that type of harassment, we're not going to look at what happened at the local 5 and Dime or whatever, or the local 7-Eleven. If that harassment carries over into the school environment, that's something we'll look at. But it almost seems like some of the harassing kids know that social media isn't covered. And usually school officials can't do anything, and OCR can't do anything, again, unless it carries over into the school environment. However, if you can show that something was posted on social media during school hours, that may give us a little window, a little wedge into getting into that claim. And I'm sure kids are on, or students are on social media throughout the school day. So I can't say that definitively, but I would certainly look at that as to us being able to claim jurisdiction or authority to proceed. I do want to stress too, regarding harassment, unless you report that to a school administrator, the defense of the school will be, hey, we didn't know about it. So unless it's clear that a staff member witnessed this harassment, this name calling, or unless you can show that this staff member keeps calling you by the wrong pronoun, or overlooks you, won't call on you in class because doesn't like the way you look or the way you dress or the way you identify, we need to have something in writing. It would be greatest if it were in writing, but even an email or something that shows that you or a parent actually complained to a school staff member. Because without that evidence, without the school knowing that this happened, and the way, if you don't have that in writing, the school is going to defend and say, oh, we didn't know. How could we have done anything? Had we known, we would have done something. And unless you have evidence of that, we can't do anything. So that's just a tip for you to know, that put things in writing, and email is fine. Just save that for us. And let's see. Wanted to share with you, how to file a complaint. That's basically it for my presentation. If you have any questions now, I'd be happy to address them.
I did get some questions in the chat, but I'm also wondering if Keygan and Asaf, if you wanted to jump in and add anything.
Well, I'm going next, so I'll just add whatever I have afterwards, but I've got nothing to, and there's a question here in the chat as well.
Let's see.
About the language of Title 12 and Title 9.
The question is, would it be a possibility to alter the language in Title 12 and Title 9 to explicitly include gender identity? Yes. I think there is a notice of proposed rulemaking being issued right now at the Department of Education's headquarters. Yeah, that's okay. You meant Title 7, and I don't know about Title 7. That would be a question for the EEOC. But as far as Title 9, they are trying to explicitly cover gender identity and sexual orientation. Again, that goes through rulemaking. It's going to have to eventually be passed by Congress. So it's a long way ahead, but there are efforts for that to happen.
Yeah, and that's what the Equality Act would do for both Title 9 and Title 7, as well as other anti-discrimination, federal anti-discrimination laws. It would explicitly include sexual orientation and gender identity into the covered categories within those laws. So this, goes beyond Title IX, and also the Fair Housing Act, the Fair Credit and Lending Act. There are many other federal laws that prohibit discrimination that include prohibition on sex discrimination. One thing I did want to say while we're on this particular topic is, although there has been some back and forth between administrations about the scope of sex discrimination, whether or not it includes LGBT people or not, the courts have been very clear, especially around whether transgender people are covered under sex discrimination, and that has been true for decades. And in Bostock, the Supreme Court really just kind of solidified that. Like, we've been saying this for a very long time, but if you didn't hear before, now you know for sure that LGBT people are covered. The discrimination against LGBT people is a form of sex discrimination. But yes, there are efforts to sort of codify that and clarify that, so you can't get a future Supreme Court to say something that says something different, or
I also got a question in my chat. What kind of protection is there for people who make complaints? Specifically, I'm wondering about staff who are worried about making a complaint in fear of losing their job.
Yeah. Well, the laws that OCR enforces, including Title IX, prohibits retaliation. That's something we would call retaliation for engaging in a protected activity. And that's legalese for saying a school cannot retaliate, intimidate, or threaten you for having filed a complaint with OCR, having filed a complaint with the North Dakota Human Rights Commission, or with the EEOC. The problem is that the retaliation happens. We can't prevent it, but if it does occur, that's something you could bring forward to the Office for Civil Rights.
And something you could also file a lawsuit,
Right.
in addition to filing a complaint with OCR, you could, if you wanted to, file a lawsuit alleging retaliation. In fact, there was a very famous case that went up to the US Supreme Court of a basketball coach for a girls basketball team, high school basketball team, who complained about the fact that the school was not giving his team adequate resources. This is probably a familiar story to many of you involved in women's and girls sports. And he threatened to complain, and he was fired as a coach. And the Supreme Court said you can't do that. That is retaliation. You cannot retaliate against people for exercising their rights under those laws, or filing a complaint on behalf of others. So again, as Anne suggested, it's a little bit cold comfort in the sense that retaliation can still happen, but there are things that are in the law intended to discourage it from happening. And there's a question about.
Oh, I'm sorry. Go on, Asaf.
No, I was going to just highlight that question for you. Is there an
Oh, yeah.
average length of time for a resolution?
Yeah, good question. Our internal, it's not statutory, but our case processing manual suggests strongly that we resolve complaints within 6 months after receiving them. We do that with most of our complaints. We don't achieve that time frame with all of our complaints. That's one of the goals of the new administration, to actually resolve these in a timely manner, so the resolution actually benefits and affects the injured student or students. So, but it's usually 6 months.
And I think just as a comparison, as a lawyer, I love to sue people. I'll kind of say that, but even I, recognize that the court processes take a long time.
Yeah.
So OCR, even though it may not be 6 months, it is likely to be faster. Depending on the circumstances, likely to be faster. I mean, I think the other thing to think about is the sort of significant difference between what it looks like to file an OCR complaint and what it looks like to file a complaint in federal court or even in state court, and the amount of energy that it's going to be required of the family and the student in those scenarios. In both cases, the student and family can be anonymous, but the OCR process is far less public.
Right.
And is really the federal government coming in and saying, it's really important to us that Title IX be complied with, regardless of, the student or not. And so we're going to, on behalf of the United States, come in and look and investigate. And so certainly the family and the student would be interviewed as part of that process, but it is significantly less invasive than a lawsuit. Again, as much as I love suing people and being in court, and I think it's a worthwhile process, it may not be right for everybody, and I think that's also important to know, because I think our society sort of places filing lawsuits. It has created a very litigious society, and so I think it's important to recognize some of those differences. If there aren't any questions, I'll kind of jump in quickly. And what I wanted to talk about with you all is kind of what to do when things aren't going well with the school district. If the school district isn't complying with Title IX and just allowing students to use the facilities consistent with their gender identity, or teachers are regularly misgendering or using incorrect name and pronouns when referring to transgender students, or or otherwise discriminating against LGBT students on campus, what to do. And I think this is not to discourage you from filing an OCR complaint, but I think there is certainly steps you want to take in advance. And I think the reason for that is it'll help OCR get a really clear sense if you ultimately do file a complaint, like what has happened? What has the school really done or not done? And so, one of the things that Anne mentioned is creating a record. I think that is really critical. Every time you talk to an administrator, send a follow-up email saying, hey, Principal so-and-so, it was great talking to you today about whatever you talked about, and sort of really detail what the discussion was about, what the principal agreed to do, what you agreed to do, or if you're reporting harassment, saying, my child, my client, I, experienced this incident, where it was, as much details as you can provide, because again, as Anne indicated, they have to know about it. Otherwise, they're going to say, we didn't know. We would have been the best school district. We would have responded in the best ways. We would have had the best words, had we known. And so it is really important. And that's not only important for OCR. If you decide instead that you want to file a lawsuit, demonstrating the school actually knew is a critical component of it, of demonstrating that they violated Title IX. Schools don't violate Title IX simply because they didn't respond to an act of bullying, or because a kid gets bullied or harassed. It's that they failed to respond in a manner that was clearly unreasonable under the circumstances. And so they have to know about it. And there's certainly, who has to know is always a big question. And what I will leave you, the thought that I will leave you with that is the person who needs to know is someone who can do something about it, right? If for example, in your school, homeroom teachers are a big part of who responds to incidents of harassment or discipline, maybe it's okay that the teacher knows. Sometimes it's a guidance counselor, but in most cases, it's going to be an administrator, like a vice principal or principal. And so making sure that they know is going to be the first step. And then to the extent it's something that, unlike bullying and harassment, maybe it's not allowing transgender students to use the correct facilities, or not respecting names and pronouns. In those scenarios, it's really about education, because a lot of school districts, despite the fact that the transgender students and the needs of trans students has been quite visible in the mind, in the media, and certainly in the state legislatures now across the country, there's still many school districts that either don't have enough information, have a lot of misinformation, or are just scared, right? They feel like they don't know what to do. And so they're kind of frozen by sort of anxiety, in a sense of like, can I do this right? What about the backlash from parents and the community? What does this mean? How do I handle it? And so engaging with them in that conversation and trying to find out what's wrong, where are they hung up, and then really providing them with information, right? I can't tell you how many school districts have said, oh, well, if we allow trans kids to use the bathrooms, what if they get harassed in the restroom or the locker room? And, in any other scenario, the issue would have been obvious, right? The problem is not the trans kids using the restroom. The problem is the kids who are harassing them, right? And if you've got a problem of harassment in school, that's a school-wide problem. That's not a trans kid in the bathroom problem, right? And so really getting them to kind of step back, or another common one is in the locker room, like, oh, well, what if students feel uncomfortable with a kid changing, a trans kid changing in the locker room with them? Well, one thing I like to do is kind of what I say, take the trans out of it, right? Create the hypothetical, but without a trans student. Let's say there was a student with a disability, right? And the student says, I don't want to change next to that student with a disability. Well, you wouldn't tell the student with a disability to go change somewhere else. You tell the student who's complaining, you can either change here or somewhere else in the locker room, but that's something for you to figure out, not for this other. We're not going to burden the student with a disability because of your discomfort. And so really helping them understand that they, one, have the tools to address these issues. It's not rocket science, right? They can do this. And really giving them those tools and preparing them as much as possible. On the flip side, I will say that, sometimes you meet with the school district, and I will say we met with a school district in rural Ohio, and they told our client, who was going into first grade, that she couldn't use the girls' restroom. We met with them several times in the summer, and they said, okay, we'll allow her to use the girls' restroom. We're totally on board. We get why our initial policy was wrong. We're totally ready. And they way underestimated the response from the community. The response from the community was swift, and it was scary. The principal received threats of, parents were calling the principal to threaten physical violence against our 7-year-old client. And ultimately, they had to, at one point, they actually stopped allowing students to use the communal restrooms in the school because they were so worried about safety. And eventually our client had to leave that school because it was too traumatic for her to stay there. So you do want to, I think it's important to build up the confidence of the administrators and the teachers you're working with, but also to make sure that they're ready for the response from the community, because they are doing the right thing, right? That they are complying with the law. The sky will not fall, but really sort of assuring them and giving them the tools they need to respond to those questions. And and I think there are a number of resources out there that help do that. A number of years ago, I worked with Gender Spectrum, HRC, and a number of other organizations to put out a publication called Schools in Transition. It's a guide to supporting transgender kids K through 12. And there's an appendix in that document that really just lists kind of canned answers to the harder questions about, for example, in elementary school, often administrators will get, well, why are you teaching my kid about sex ed? They're in elementary school, and there's a very clear answer. This is not about sex ed at all. And really kind of giving them answers that they can kind of fall back on, so that they feel prepared. And really, so again, I'm encouraging you to engage in that dialogue with them, and again, documenting everything, because whether you file a complaint with OCR or decide to file a lawsuit, those documents are going to be really important. The schools won't keep those documents for you, and the documents they do keep are not going to be as clear as the documents you keep for yourself. And one thing I would say sort of on documents too is, if you're working with a young person, encourage them to keep a journal that sort of talks about not only the incidents that they experience, if it's bullying and harassment, but also how it makes them feel. I will say, I filed in 2011 a complaint with OCR on behalf of a trans kid who was denied the opportunity to room with his male friends at an overnight science camp. And I had him keep a journal while he was there. And he wrote in his journal that he felt like he was being quarantined, that he had some disease that was going to be spread to his peers if he was allowed to stay with them. And obviously the idea of quarantining has a totally different meaning of feeling now. People can relate to it a lot more now, but even then it was a really powerful sentiment, and I think really helped not only the attorneys from OCR who are doing the investigation, but I think it also really helped the school administrator understand why this was so painful, and how it so negatively affected his ability to really gain anything from the science camp that's supposed to be the super fun event. It's the first time you're away from your parents without, a school trip, without, and in nature. And so, I think having a journal can be really impactful. The other thing I did want to kind of say, and then I'll turn it over to Keygan, is about privacy. One of the things that has come up a lot is when can schools keep things private and when shouldn't they, and all those kinds of things. And I think what we like to tell school districts is that the goal is always to promote and increase family acceptance. The first and foremost, all the research demonstrates the importance of family acceptance to a child's short and long-term health and well-being. And schools should really be a part of that, in the sense that they're a neutral party, right? They don't have any stake in this other than the child's best interest, right? They're not raising the child, but they can be a great source of neutral information. At the same time, immediately disclosing a transgender student or an LGBT student's sexual orientation or gender identity to the child's parents is not necessarily going to be the way to promote family acceptance, especially if the young person has concerns about, especially their physical safety, if there's been a history of mistreatment, physical or emotional, in the house. And so I think, it's really important to look at it on a continuum, that it's not like, okay, we decided we're not going to tell and we're never going to tell. It's really about creating a plan for ensuring that when the student comes to school, that they feel safe and supported so they can flourish, and also to help build, again, family acceptance so that when they leave school, they feel just as supported and can flourish outside of school. And with that, I will turn it over to Keygan.
Thanks, Asaf. So we've talked about the official ways of getting response when bullying, harassment, or any of those types of things are happening, whether that's through OCR, whether that's through lawsuits. All of those are responsive actions that we can take when students have had their rights not respected and so forth. But before any of that happens, we want to be on the preventative side. We want to talk about what schools can do, what students can do, what parents can do to prevent all of that from happening to begin with. I actually want to make Anne's job easier, and I don't want to give Asaf any clients. Is my goal here, is to prevent all of that from happening to begin with. Work ourselves out of a job, right? So the way we can do that is in two different ways, really. One is through policy, and the other is through our practices. And so we want to make sure that our schools have robust policies around bullying and harassment. GLSEN has a really good example of a great bullying and harassment policy. There are several other organizations that have put examples out there of not only the policy itself, like what they can put in a school board document, but also how to implement that. How do we train teachers to recognize these instances? And not just teachers, but other staff members as well, because we know that bullying and harassment happens in the cafeteria and on buses and other places that are considered to be part of school. So we want to make sure that all staff are aware of those things and how they can react, what the process is to dealing with it and de-escalating and responding, and that sort of thing. So after I'm done talking, I'm going to drop a bunch of links to different model policies and practices in the chat. Another thing is to make sure that the schools allow for GSAs and explicitly allow for GSAs, so that way there's never a question of whether or not a gender and sexuality alliance or a gay straight alliance, depending on what you call it, can exist. Making sure that schools already have that policy in place. Non-discrimination policies that include both sexual orientation and gender identity explicitly for both students and staff can make a huge difference in both, stating the claim of what the school intends to do, but also in response when those things are happening. I would be remiss as the Trevor Project, as the representative of the Trevor Project, to not mention suicide prevention and mental health. These are policies that help all of our students be safe and supported in a variety of ways on campus. And then trans-specific inclusion policies, whether that's around facilities, name and gender changes, sports participation, all of those things. If our school districts already have in place policies on how to ensure that our trans students are included in all aspects of school in a safe way, then when that trans student comes out, we're not dealing with a reactionary moment, but instead we already have how to work with those young people, how to work with their parents, how to make sure that all of our staff are on board and ready to go. And there's plenty of examples of how those inclusive policies can exist. And I'm gonna, again, drop one of those in the chat momentarily. So policies one side, the other side is in our practices, providing LGBTQ inclusive curriculum. So that's, not just teaching about, LGBTQ history or including sexual orientation in health courses when we're talking about relationships or sexuality education, those types of things. It's also talking about, the contributions of LGBTQ folks, talking about LGBTQ topics in literature. There's so many ways that we can have that LGBTQ inclusive curriculum that's going to build a better understanding amongst our students and our staff, and really create a community that is a more supportive environment, which will prevent a lot of the bullying and harassment from happening to begin with. Having teacher and staff training on LGBTQ competency, just making sure that everyone's on a base level understands what LGBTQ issues are, some basic understanding of the culture and community, and being able to identify when someone is being harassed. Our students are masters at new language and new ways to cause all sorts of ruckus. As a former teacher, I know half the time my students would say these words and I'm like, well, what are you even talking about? And so making sure that our teachers and staff are up to date on, what does that word that my student keeps using mean? And is it a derogatory term? And if that's being thrown at another student, then I need to intervene. And so making sure that folks are up to date on those types of things consistently. Having readily available LGBTQ resources. So whether that's materials in our libraries and our counseling offices, whether that's making sure that there are, posters on the wall advertising the GSA, or posters advertising Trevor Project services, any of those types of things are going to, again, have a more inclusive environment feel. And then of course, having a GSA on campus is always a good way to make sure that our LGBTQ young people have affirming spaces. So that way, they'll be able to deal with some of these issues and have that supportive environment. So I'm gonna go ahead and drop a bunch of links into the chat. I hope that you'll take a look at some of these, see if your schools have these inclusive policies and practices. And if not, pick one and start working towards that, because every little piece that we can put in on the prevention side will prevent that bullying and harassment from happening overall.
And those policies will help the school districts comply with Title IX. I think that's one of the things that, often gets missed is, parents will often say, well, doesn't Title IX require a school district to have a policy? No, it just requires them to comply. And having a policy really guides administrators, teachers, guidance counselors, whoever is interacting with students on how to behave appropriately so they don't violate Title IX. And that's, going back to Keygan's point about prevention, that's really what these policies are, is that they really educate those that don't know necessarily immediately what to do, or maybe that their initial instincts are not the best, or lead them to do the correct things naturally. It'll give them an idea of what they should be doing, and kind of as a kind of a practical level of like, okay, a kid comes out to me as trans. Do I need to call somebody? Who do I talk to at the district? What does the process look like? And some of those practical questions can be answered through those policies.
And two, a lot of times when we bring up these policies to begin with, school districts are concerned. They're like, well, isn't this just a lawsuit waiting to happen? And to Asaf's point, like, no, this is actually your first step in preventing that lawsuit from happening. If you don't have the policy, you're going to mess up anyway and not be in compliance with the law. So it's better to have that policy so that way you have a more likely chance of complying.
Yeah, and school districts, interestingly, are often very worried about being sued, but never by the transgender students, even though the transgender students have been the ones regularly suing school districts and winning. And I think it's also important to note, to the extent that your school district is particularly afraid of this, every time that a non-transgender student has sued a school district to try and block a school district from enforcing its own anti-discrimination policies, the courts have said, no, you can't do that. That having a transgender person in the locker room does not violate your rights under federal law. It does not violate, it doesn't violate the Constitution. It doesn't violate Title IX to have a policy that treats transgender students with dignity and respect. And so I think that is another key point, is that, if they're really worried about losing lawsuits, they should worry about losing the lawsuits filed by transgender students and not ones filed by non-transgender students.